back. It turns out Randy and I have a lot more to discuss, and we thought we might as well turn the camera back on for our listeners to enjoy. And this time what we wanted to do is a bit more of a deep dive into Randy's experience intervening at the EUB, because he has some good stories he wants to share with us. So tell me a bit more about, you applied to be an intervener,
Yep.
you got accepted,
Correct.
and now you have to show up, which initially was a simple schedule.
Right.
And everything got turned upside down. So tell us a bit about your experience at the EUB.
Yeah, this was a very unusual year. They had set aside 15 days in May for this hearing, and as you can imagine, you have to coordinate this months previous, because you're dealing with experts from the States or from out west and consultants and lawyers, so it's quite a thing just to be able to convene everybody and get everybody's calendar. And the EUB requires 3 board members to participate and form a quorum in its deliberations and its hearings. And some vacancies were on the board, unfilled, so there were only 3 EUB members available. And a week before the 15-day hearing was to start, the chair was involved in a car accident. So they lost quorum. So a week before the hearing, we got notified it's adjourned until they can revive a quorum somehow. And so a new board member was appointed, and after only 3 weeks in that position for him, they commenced again. But you could only imagine the scheduling issues and difficulties. They're trying to fill lawyers' calendars and line them up along with experts, in this case from Alberta and from the States. So the 15 days were spread over 3 months. There were like 4 or 5 days in June, another 6 in July, and then it wrapped up with 2 different sessions in August. So,
but it's more complicated than that, because the initial rate application from NB Power was already delayed last year.
That's right.
Since they got a new mandate letter pushing their debt-to-equity ratio to 2029 instead of 2027.
That's correct.
So you already have a shift in the schedule by a few months.
Right.
And now another giant
Yes.
shift in the schedule. But what I wanted to ask you is that when these delays happened, NB Power filed for an interim rate increase,
Correct.
which is still kind of ongoing because no decision has been made.
Right.
So what are your thoughts on the EUV just approving that interim rate increase?
Well, that was argued on a motion before the board, and arguments were made. I thought compelling arguments that, well, listen, you've got to hear the evidence before you can introduce and enforce an increase. But the more persuasive argument apparently was that there would be an incredible loss of income on a monthly basis to NB Power. And when you look at the amount of lost revenue that 10% increase would otherwise have provided, it would have meant either a larger increase in the event that they were entitled to something near double digits. So it was a bit of a surprise to some of us, and others weren't surprised. It was just a decision that they made to accommodate the concerns of NB Power that they would lack revenue that otherwise they had planned for in their revenue requirements. So yeah, for a host of reasons, and that whole debt equity situation by the province and the condition now that it be reached 20% by the year 2029 rather than 2026, and an argument before the board is that that's somewhat artificial. As we got into this, some were suggesting you can push it out even further. There's no reason to really... And that just led to so many concepts of, rate smoothing, rate riders, variance accounts. When we got innovator status, I looked at the GRA, it was 361 pages. That was just the general application. And so I then downloaded it into a PDF, and I said, well, let's see how many times the word poverty is there. No. Let's see how many times low income is there. One reference to a residential sort of thing. So I thought, okay, well, we've got our work cut out for us, And then I learned that the way these things proceed is that NB Power produces and introduces a revenue requirement. It says, this is how much money we're going to need in the next year to provide reliable, efficient, affordable energy. And there are 8 categories that they list. Everything from fuel and purchase power expense to operations management and administration to depreciation and amortization, taxes, finance cost and other income, net change and regulatory balances. And so then they set out a schedule because NB Power presents sort of its evidence by way of the GRA and then makes available for cross-examination 13 separate panels of experts within the corporation that can answer questions related to this revenue requirement. Well, I clearly, and nor were we as an organization equipped to deal with a revenue requirement. Who are we to say, you don't need that much for fuel? Your depreciation isn't that much, or your amortization is wrong. We really couldn't do that. But that was the role of some of the other interveners, and they retained experts. The other thing, I mean, we can talk about going forward as civil society in these rate hearings, but it was pretty clear from the outset that in order to properly intervene, the way the system is currently set up, you need a skilled litigator and an expert. I think without either of those, your ability to participate effectively is compromised. And so we had neither, but we did the best of what we could, and we sort of learned as we went. Fairly legalistic in its approach. It's typical cross-examination of witnesses and of panels. And each panel that's there, the opening one was panel A, which was the CEO and the two senior vice presidents of the corporation. And that's where, with hindsight, we probably would have approached our introduction differently. I mean, that is the policy group. That's the group, and that's the opportunity to raise questions of policy. Those are the folks that can answer those questions. We were warned in advance, in reading transcripts from previous rate applications, it wasn't uncommon for panels down the road to claim that, well, that question is a policy question that would better have been put to panel A. So you had to sort of pick your poison and know when to put the questions. And so that first one, and that's when all the media was there, and that was the first day of the hearing, that's when the CEO was there, and that's when, policy questions or questions of policy should be put. And then after that, you get into all the nitty-gritty of we'll need this much fuel, and then, of course, the experts that can challenge the components of the revenue requirement go into the assumptions that are made by the utility as it's crafts its numbers, as it makes its case. So the cross-examination of the panels dealt with challenging some of the assertions, digging deeper into the assumptions that went into the formulae that led to the numbers that were produced. The overall requirement was $2.587.9 million, $2.5 billion is what the utility said it needed in the next year to fulfill its mandate and to do its work. And so retained experts produced their own reports, did their own analysis, and then challenged the utility on some of their statements and some of their observations and some of their requests. And even at the end, during summation, the chair asked if I wanted to opine or had an opinion on costs or what could be cut, and I said I couldn't. I mean, I didn't fall asleep during amortization. I saved that for wind balancing. But I was really struggling with some of the concepts, and that's why you do need experts that know how to do this sorts of thing. And thankfully, the public intervener, for instance, has a handsome budget for experts, and the two experts that he retained were, in my opinion, very, very effective and very good at what they did. And the same with the board's expert that they retained. So there were experts that were meant to challenge some of the assertions of MB Power. And you saw that over, for instance, Point LaPro, when it came to planned and unplanned outages and what a reasonable expectation would be for their provision of electricity, which is about 1/3 of the electricity produced is from Point LaPro, or PLINGS, as I learned. There's so many acronyms.
There's
in this.
a lot of acronyms.
It was just everything from PROMOG, which is that software that projects the uses, and then PLINGS, the Point LaPro Nuclear Generating Station, and PACT and PAC. So I had 2 pages just of acronyms, to work through this. But it was a pretty, I've had people describe it as an arcane process, but to the uninitiated, to somebody unfamiliar with a legal type proceeding, I think it would be very difficult to follow and to intervene effectively.
I agree, and when you look at the EUB website, for example, all of the documents are available online.
Yes.
But trying to find those documents I don't know if any one of our listeners have been on that website. It is
Yeah.
a very difficult website
Yeah.
to navigate.
Yes.
And I remember when the general rate application was filed,
Yeah.
since I know the website, I found it and I saw
Right.
300 documents uploaded day one.
Yeah.
Right?
Yeah,
So
yeah.
it's like, even though theoretically the public has access to these documents, it's quite inaccessible unless you know what you're looking for.
Yeah.
And even more so that if you do care about these issues, it is difficult to intervene. You, as you mentioned, you need to have that expertise. You need to have litigation. You need to have witnesses. And actually, I kind of want to bring that in. Like, one of the issues that I saw at the UB was how difficult it is to bring data forward.
Mhm.
So how did you get your energy poverty reports submitted as data to the EUB?
Well, that's a great question, because typically opinions can only be voiced by experts, and experts have to be acknowledged and approved by the board. The board has to acknowledge them as an expert in this prescribed form, and there's a process that goes. CVs are read, questions are made as to experience and what's your relevance and what can prove to us that you know what you're talking about, sort of thing. So we wrote the paper on energy poverty, but I didn't seek to qualify our data analyst or social researcher as experts. I think they probably wouldn't have passed that threshold test of being able to provide opinion evidence, but nonetheless they were able to present data and what the data showed, and what we hoped that data would lead to in terms of improvements or public policy or a low-income rebate measure. But the two of them served as a panel. They were cross-examined by all the interveners, including MB Power.
Good on them.
So it was a great exercise for them. They acquitted themselves very well, in my opinion. And I think we accomplished a part of what we set out to do, which was to sow a seed, to talk about energy poverty. And it came out from Panel A in the first day, the statement from one of the three principles of MB Power that energy poverty is real in the Brunswick. So just to have that phrase, that comment, that acknowledgement, I think will allow and open the door now to a discussion of, well, what does this really mean then? How was it created? How was it overcome? What can you do to reduce the burden of energy costs on in particular low-income residential customers?
Do you mind walking us through, especially for our viewers who've never intervened like we have, but what is that day-to-day as an intervener, and any comments on the other interveners and that whole process discussing some of these complicated issues?
Well, the day they decided, because of the way they had to sort of carve up the 3 summer months to get 15 to 19 days, that they started early at 9 and went late until 5. With a break for lunch, 2 15-minute breaks, one in the morning, one in the afternoon. But it had its own pace and its own rhythm. It was clear that some panels would be subject to more rigorous cross-examination than others. There was quite a discussion, for instance, about Point LaPro, about Mac to Black, about Beldoon, and Colson Cove, the principal generators right now, and some of the challenges that they have. And there are real challenges in New Brunswick with respect to power and going to net zero and getting off of fossil fuels. And then what do you do with municipal utilities that have their own sort of wind farms? And how do you deal with individuals that want to get on the grid and generate their own electricity? So there's a possibility of some distortion happening very quickly. Faster than we would probably think in the next little while, as to how, federal regulations in terms of emissions and efficiencies work their way through the system down to provincial utilities and then down to residential customers. So the day would start off with appearances, and in the sense that every intervener who was acknowledged and identified as an intervener would be asked to attend or appear, and each time, for instance, the Canadian Federation of Independent Businesses, the Manufacturers Association of Canada, Forestry New Brunswick, they were all interveners, but they never appeared. They didn't participate in the hearing, so I'm still a little puzzled as to that piece. They may well have submitted final written arguments or a submission, but they weren't active at all in the examination of witnesses or cross-examination, or they provide their own experts on this. So experts were provided by the public intervener and by the Energy Utility Board itself, and by our two little folks that we talk about energy poverty. And that's there was a lot of reading involved. There was a lot of trying to understand some of the concepts of utility regulation, of this cost of service monopoly, the role of the board, and that goes back again into the other thing we had hoped to accomplish is a resolution of this question of jurisdiction.
Let's touch on that because we've talked about this before off camera. Let's bring it onto camera. The role of the board specifically.
Right.
And we have differences of opinion. We agree on the same page here, but the board thinks their jurisdiction is. Do you mind elaborating what they think their jurisdiction is and some of the issues with that?
Yeah, it's my understanding that they draw a line between the role of the province, which is social policy, in their opinion, and the role of the utility, which is to be efficient, to simply produce a revenue requirement, say this is how much money we need, and you divide it out amongst the classes, heavy industrial, general service, residential customers, and you adjust your rates according to the math. So the challenge, of course, is to attack the math and to take a look and see if these assumptions that they're making are appropriate, whether their assertions have any validity. And that's not for the faint-hearted at all. But it was quite a learning curve. The council that I saw there represented were very effective. I thought they knew their business. They knew their clients. They knew the regulatory piece to it. When you think about it, the EUB has a lot of hearings. You participated in some of the hearings yourself, and so I appreciated your counsel over the time of the hearings, thinking, is this normal? And but the whole the CCAS stuff, the rate design, this was just a GRA. This was just a general rate application, which ordinarily had happened almost on an annual basis. In this case, it was a 2-year one.
Right.
Now, when the utility states that it doesn't have a mandate or jurisdiction to differentiate amongst classes, it can't distinguish between low-income residential ratepayers and ordinary ratepayers or affluent ones. They're blind to that, they claim. But then again, you think, if you can't distinguish, the very fact that in this province we each pay for the same kilowatt hour, the same amount, suggests to me that surely there are some communities or individuals on the grid that are being served that probably have a higher cost of service than if you were in a dense urban area where you don't have transmission or distribution challenges that you do in rural areas. So in a way, affordability is almost dealt with there. They do distinguish and compensate for that. And the other piece, with the 2-year rate application, they were doing rate smoothing. And they were saying, unless we had done 2 years at 9.25 each, then the first year could have been like 14%, and then it might have been 7% the next year. So we're going to smooth the rates. So arguably that in itself includes some delving into distribution and ability to pay and that concept. So I think there are almost built-in ways that ability to pay is dealt with by the utility, but there's a reluctance around and willingness to be more overt about that. Now, other provinces have dealt with this. Ontario has the OESP, it has a residential low-income rebate. But its legislation, each piece of legislation, and there are 10 provinces, each province has little tweaks to legislation. And so while MB Power argued that it didn't have jurisdiction, we took the position that section 108.3 sub E, which says, in setting rates, they're allowed to take into account, here it is, any other factors that the board considers relevant.
Okay, so a very broad-based sentence here.
You could drive a van through that one, so maybe that offers some jurisdiction. So I'm hoping out of the EUB decision there'll be some comment about jurisdiction, because that needs to be settled. Because civil society has to know where to put its efforts. We're way too thin on the ground. For reasons that we spoke of earlier, civil society is way behind in New Brunswick when it comes to other jurisdictions. We're the only province without a sector council for community nonprofits, for instance. So it's a real challenge in this province. Again, the lack of that dominant urban area, that 500,000 people that can give you some think tanks, some capacity, and some resources to work with. So we'll see what happens. And once we get an opinion on the board, then we can choose to arguably challenge that legally, which would take time and resources. Or maybe that's a sign to us, to all of us, that our efforts have to be focused on the province, and the province has to step up, because low-income rebates generally are either ratepayer funded through utility bills and contributions and assessments, or taxpayer funded, where the province would undertake to fund a rebate of some sort. So that's the challenge. We start off with the assumption that we need a low-income rebate, that it's necessary, it's applicable. Unless you bring this about, you're going to have increased missed payments, greater number of arrears, forced repayment plans that have rules that we talked about, and these rules, I think, leave many people out or don't serve them properly. So we got to know where to put our efforts,
right?
Where we lobby, where we assert the interest and provide the voice for those that don't have voice at these things.
When I think about last year's rate application, for example, NB Power filed, I forgot the exact amount, but 8%, and then the EUB approved a 5% increase, for example. Yeah. So right now, the rate application is almost a 20% over a 2-year rate increase. How do you think the board's going to right now, no decision has been made because the hearings ended relatively recently, but do you think that they will accept that full 20%? And how does the board balance between the EUB's, the NB Power's mandate to get to that debt equity ratio, and between raising rates to make it in the affordability crisis that's going on? I mean, what is the priority? Do we prioritize this affordability crisis, or do we prioritize NB Power's mandate? I always thought there's an obvious answer here, but it doesn't seem so obvious once you get to the EUB. So what are your thoughts on that?
Well, if the utility is a cost of service utility, if it's allowed to recover its legitimate costs, and its costs are determined by a revenue requirement, then the EUB, I don't envy them at all. It's a really difficult Solomonic decision to have to make. I mean, at what point do you what is the revenue requirement? What is proper? The assertions and the statements and the projections provided by the utility, are they unquestionable? And if not, I mean, then you run the risk of the EUB, and this was explained by Ryan Burgoyne, a wonderful lawyer from Costin Palmer, on behalf of the Utilities Municipal, and he said, if not, then the EUB becomes almost an insurer of whatever NB Power wants, if you accept everything that they say. The board, I think, is going to have to sort of make those sorts of decisions, and they'll make those decisions based upon the evidence. And I keep coming back to evidence.
Evidence was something I struggled with deeply when I intervened, because we didn't have the budget to bring in the expert witnesses. Right? And we're a nonprofit. We don't have a lot of budget, but we had a lot to offer because we intervened at the cost of carbon adjuster. And it was a strange dynamic where the board was very honest about having very little to no data, and then they make a decision, and on two sides of the coin, there's industry and the people who have to pay at the pump. And at the end of the day, it always felt like, even though there's no data, there always a bit more industry.